This is The Last Word.
All right, good evening everyone and welcome to The Last Word. We do this show every Tuesday where we take one issue and we boil it down to make sense. So this week we have yet another hot topic, and the question tonight is LSK elections, the upcoming LSK elections that is less than 3 weeks out. Now the question we're asking is, do we think as a people that the LSK has a greater responsibility to the public, or it's a society and organization for lawyers' issues? That is the question we're asking tonight. But I do have a room full of lawyers. In other words, it's never a good thing. It means you're either in trouble or there's something happening somewhere. I do have Zaha Idimuli, my co-host, and Eric Latif. Lady, gent, good evening. How are you feeling about today's show?
Boiling hot. I'm completely interested to learn, but also to question the learned friends. There's so much. We're viewing 2027 on Limelight. I think I want to know, learn, and also poke their minds into what they're thinking and what they're planning. It'll be interesting.
Indeed, we have several candidates vying for different positions, and you will get to hear about the position that they want to run and the issues that they're fronting. We also have the vice presidential candidates with us here, and we thought it's a good opportunity to hear what they would like to offer. I do have Teresia Wavinya, Deborah Ajwang, and Wanjeri Elizabeth Mangui, among other candidates that we will be showing you as we go to the show. Latif, the question tonight, before we hand over the show to the real owners of the show, do you think that it is possible that lawyers can think of this moment in this election that we need people to get into office who would think about the 2017 elections, or the issues in the profession are profound and they're big and they're important? And is there space to balance these two issues?
Well, observing the campaigns and the conversations around this election and the previous elections for the Law Society, where the electors are the lawyers and they're electing their leadership in various stages, I think the primary thing that always comes to mind for the electors is their welfare. And then the secondary thing is now the broader national conversation and public interest. But then as they get into office, we see the LSK Council, for example, they handle a lot of, I'm sure, a lot of lawyer welfare issues. It's just not publicly. What we see publicly is what the LSK is doing to advance the rule of law, to advance public interest, and even taking up public interest litigation and so on and so forth. So we see that after the election, after somebody has come into office, the members of the public have often not even participated in having discussions around who is the next president of the Law Society of Kenya, or the vice president, or members of the council, or even members of the various, the leaders of the various branches. We don't even know the branches, right? So I think it's trying to mix those two. To the lawyers, their primary concern is, I studied law and I want to practice law, and what's the best way I can practice law and make it benefit me? And who is speaking a language that I feel associates with me? That's publicly. Right. Chini though, the truth is, just like the national election, the professional elections in this country always go the national way. You will find what's a main political leaning in the country at present. Is it Kenya Kwanza, United Opposition kind of conversation? You'll find it in the Law Society of Kenya. It'll emerge tonight.
Okay, that's a good place to set this. Let's have Teresia. Where is the microphone? Yes, Teresia, let's start with you. Help us. If we were to think about this election, how should we frame it for lawyers and for the public? What is the key most important thing we should think about this election?
Thank you very much for that question. Well, when you look at the Law Society Act, Section 4, it is very clear on the mandate of the Council, which not just include advising the government, upholding the rule of law, and also becoming a welfare outfit for the members of the Law Society. So, for this election, as we are campaigning, we are trying to bring out that balance, first and foremost for our members, just like from the inception of the Law Society. When it was being formed, it was formed as a welfare unit preserved solely for members of the bar. To the extent there was a caveat that they should not be involved on matters to do with the politics or interfere with the colonial order. It had to take the Mau Mau issue for advocates then in the 1950s to actually defy and start speaking on behalf of the public. And fast forward, through an act of parliament, the Law Society Act, we have that mandate to speak on behalf of our members and also to speak on behalf of the members of the public.
Mm-hmm. All right, Wanjeri, do you think the issues today, as we speak, there is many questions that I've seen through this campaign of the questions about the welfare of young lawyers and their place and space in this profession. And it appears almost like a defining issue. Do you think there will be space for national issue? For instance, where were everyone during the Mandamano? You know, is that an important question to ask now, even though we have an urgent question about the welfare of young lawyers specifically?
Thank you for that question. I think both issues are very important to the legal profession. And as you look at LSK, the mandate of the Law Society of Kenya is under Section 4 of the LSK Act. And if you look at it, it gives some of the key core mandates as assisting the government and courts in administration of justice and even legislative matters and the practice of law. Now, in as much as the LSK, the core mandate is welfare and practice issues to the members, but public interest issues also form an important factor when it comes to the Law Society of Kenya. Now, you will see that even in the strategic plan for the Law Society of Kenya, public interest forms one of the priorities. So yes, regardless of the other issues that we attend to, LSK is an important partner when it comes to public interest matters. Remember, even one of the core mandates is to actually help the members of the public in matters when it comes to legal issues. So I think, yes, in the midst of all these issues that plague the legal profession, and welfare is one of the key aspects, yes, we can find a space for public interest matters. And remember, LSK is actually, I think it's the only statutory body that is not funded by the taxpayer. So I think we do a lot, and we're an important partner. Yes.
Wanjeri, I have a question for you.
Yes.
Permit me to take it away from the borders of the bar.
Yes.
I want to understand, from the Law Society of Kenya's statutory mandate, how then does LSK define its responsibilities to the public, and how does it assess whether its interventions are effectively protecting citizens' rights and the rule of law?
Well, I think when it comes to assessment, it is for the public to assess us. And I think so far, from the feedback even we get on our social media handles, from various people, they are very satisfied with the job that LSK has been doing. In fact, if you look at the previous years, no one was tagging LSK in even the social media handles. But in the past 2 years, anything that happened, LSK used to be tagged. Now that should tell you that LSK is an important partner in this, in that they feel LSK, once the contribution that LSK will be an important factor in this.
That's very correct. I'm asking on the mandate and self-assessment within LSK.
Yes. So what I'm saying is, now when we look, that's part of the self-assessment, because we also need to hear the feedback from the people that we are fighting for, really. So if from the social media handles they're actually saying they're happy, or they're tagging you saying look into this, then it means actually they trust you. Now also from our other partners, when you get the civil society coming to you saying let us partner in this, and they're actually saying that you're doing a good job in that, I think that should also be a key indicator that LSK is doing a good job. Now, as to the mandate is it's up to the LSK now to look at the issues that are arising. Remember, when the issue of the demonstrations came up, no one would have ever anticipated that there would be in 2024 that there would be demonstrations. So it is up to the leadership to actually think on its feet as and when issues arise, so that they can actually address them as and when they arise.
Okay, so let me go to Deborah before I open up to everyone, because it's just opening statements. Deborah, do you think, with the evidence, and this is a good place to start, of what happened in 2024, we had protests and the LSK leadership had to show up, and perhaps this is the first time in as many cases that Kenyans sort of got introduced to the role of LSK, and a president who was in tune with the times, and she understood her assignment, if you like. I want you to assess this current, you guys who are running for office, and I want you to be honest with yourself as you campaign for yourself. That do you think there's a faith in people that you've seen? And I'm happy for you to say that you are the faith.
Interesting question. First, I'd like to just correct you from the perspective of this is the first time that we've had the LSK at the forefront in demonstrations. Historically, the LSK has done that. I mean, if I mention people like, James Orengo and other senior counsel, they have been at the forefront. And I think it's always important to look back at history and acknowledge that. Gen Z had a very special and unique manner in which they carried themselves, but it's not the first time. So do I think that we have those kind of candidates? I'll let the members decide. I think there's a space for balance. That's what I'll say. There's a space for balance. When the constitutionalism and rule of law is not upheld, then we as lawyers are also impacted. We've had scenarios where lawyers have been disappeared. So whilst we may want to concentrate, and yes, we have a mandate to focus on membership, but it has to be a balance. Because when there's a breakdown in respect for the rule of law, it affects us directly. So it has to be a balance. I credit the Faith Council for doing a great job in that, but I think there was room for balancing. That is what I'll say.
What does balancing mean exactly?
So by balancing, I mean, yes, there's our role to protect the rule of law, and that was done very well. But then in some instances, the membership feels like it was neglected. And remember, this is a member society. Going back to the question that you have asked, are we just going to, a society that is member-focused or public-focused? And the answer is, it is both. So you cannot have a focus, as we've had, on one end and then neglect the other. There has to be a balance. And the way to do that, in my view, is just have proper structures. When you have proper structures, then the president is able to delegate these responsibilities because we have structures, committees and all. Then you have a balance.
Okay, let's open it up, okay? There's many people in the room.
Yes.
Please, where do we start? Sophia? Yes.
I'd like to echo the sentiments of Deborah insofar as acknowledging our seniors and those who came before us. And an example is Senior Paul Mwite. And many may not know, but when he was president of Law Society in the early 90s, he's the one who was at the forefront of fighting for multi-party democracy. So I think it's also our mandate to remind the younger generations of the work and the incredible work that the Law Society of Kenya has been doing for decades. But I'm really happy that Faith Odhiambo's leadership and the current council has done a lot in terms of amplifying that work and being present when the nation needed Law Society of Kenya. So I just like to acknowledge that to begin with. And there has to be a balance. Listen, if our members are hungry, if they're not eating, if they're not able to pay their rent, if they're not able to sustain their offices, if they're not able to make families, then we're not going to have a stable and strong membership that is able to even serve the public. When you're in an airplane and there's turbulence, they say that you must put the mask on yourself first before putting it on your neighbor. And that's what we need to do as Law Society of Kenya. We need to focus on our membership first. We need to be a council that fights for our membership to ensure that they have their welfare issues taken care of and to ensure that they're able to practice in the best environment possible. So as a general member representative candidate myself, that's one of my biggest priorities. When it comes to the public, I'm a human rights defender, I'm a human rights activist. I have been doing public interest work for over a decade.
Right.
And that is extremely important for Law Society to be present for the nation in this moment. James, you talked about that we're going into an election year. This, I think, is going to be the most important role of council, to ensure that there's stability, to ensure that rule of law is respected, to ensure constitutionalism, especially in this period that we're in right now. We have come from a revolution, we are still in a revolution, and we need an LSK, a strong council that believes in the rule of law and is ready to be at the forefront of protecting our members first, and then protecting the nation.
So, I have a question for you before you proceed. Do you think LSK has mechanisms that already exist or can exist where members can raise these welfare concerns and influence policy within LSK? And how then does the society measure whether its welfare interventions are effective and inclusive across counties, specifically because LSK has now had this whole mandatory alignment around its Nairobi-centric. Is there space within LSK where these concerns can be raised, and how does it done?
We have structures within the society, starting from our annual general meeting and other mechanisms within the Law Society of Kenya to address welfare issues. We have committees, we have branches, we have chapters across the country. But what I will say, and I'm not afraid to say, that all these welfare issues sometimes are centered within the big towns. I myself have practiced in Kilifi for the last 3 years, and I can tell you, for advocates who practice in far-flung areas, for advocates who practice in small towns and villages, sometimes we are left behind. So I think it's really, really important to ensure that we place structures and we create mechanisms where every single lawyer, wherever they are in the country, have their welfare needs taken care of.
I'd like to ask the question, what are these welfare, what would you say is the most pressing welfare need for those of us who don't practice? We just know lawyers are about that we pay them.
Eric, we're like you.
So
we have needs. We have medical needs. We have social support structures that are necessary for lawyers as well. Sometimes you feel very isolated as a lawyer because you don't have a mechanism to be able to ask for help when you need it. So we're talking about medical support, social structures to provide support. We're talking about, and Deborah raised this, that one of our advocates was killed. Right? So we're talking about serious protection issues as well, because the public expects lawyers to be at the forefront of these fights for public interest. But we forget that the same lawyers also face retribution. The same lawyers are also facing arbitrary arrests. The same lawyers are facing surveillance. So we need to protect our members. Otherwise, if we don't protect our members, we won't be able to serve the public.
Let's take one issue, medical, right? So this is not a union, right?
Right.
It's a society. So how would you address members' issues on medical? I mean, how does this look like? Just break it down for people who are not lawyers.
You have a card, right? So you can raise it up if you have an issue, so that we can get the microphones to you as quickly. Yes, please.
Yes, thank you. Thank you so much for that question, Eric. My name is Abner Collins Mango, advocate of the High Court of Kenya and General Member Representative position candidate. Don't be too worried. For that position, they pick two. So different positions, there are different numbers. No need to worry. You can vote for both of us who are here. So just to answer that question, expound it a bit. Now, the previous council, what I've seen they did is, for example, negotiate for a medical scheme for advocates. So they went and I know Teresia and Wanjeri are serving in the current council. They can expound on it. So they were able to negotiate for a medical cover. But in terms of looking at it even in a big and wider perspective, and now that we are now talking matters health, advocates are also, they're human beings. So we're also having a lot of mental health issues. So advocates, and sometimes in terms of the nature of the job we are doing, it comes with a lot of pressure. Some briefs come with a lot of pressure. So some even collapse in terms of their mental space. So we need a society that looks even into their members' mental health. But having gone around the country and getting members' views during this campaign period, one thing that also really stands out is an issue to deal with the advocates' remuneration order. So this is the order that regulates what advocates should be able to bill. And the last time this remuneration order was reviewed was in the year 2012. At that time, we were around 8,000 members as advocates. Now we are in 2026, we are now looking at around 27,000 advocates. So advocates are saying, now look, let us have a remuneration order that speak into the current economic times that we live in, so that whatever you are paying as bills in the year 2012, in terms of now the current economic times, really would not be making sense in the year 2026. So those are some of the things that members really want to be looked at. And then just finally to mention, as I finish on that space, now last week we saw something crazy happen, and I know Eric and the rest, you'll talk about this. Now, orders were issued in a court sitting in Nakuru, barring advocates from, transacting or representing the government.
Entities.
Yes,
Yeah.
and public instead, in court. And the petitioners in that case have an interesting argument and say, look, these state agencies have legal departments, or these county assemblies have legal departments. So why should you come out and give this job out to private practicing advocates? But look here, you cannot have one size that fits all. Some of these counties you'd find have, say, 3 legal officers. They are not in a capacity to represent ably the county in all these matters. Again, if you look at it in another manner, for example, during election petitions, we have the Independent Boundaries, Elections and Boundaries Commission. Now, elections petitions will be filed all over the country, and these are matters that should be determined within 6 months. So then how would IBC's legal department handle all these issues in that manner of time? Now, the other day we had something like Adani, for example, was a big thing in Kenya. And now this is a multi-national kind of contract. So for example, if the legal office in government or the whichever ministry, is it transport that was trying to fix this deal, you cannot be a witness because you are the drafter of, for example, this contract. So then how do you go to the same case and represent yourself in the case? So those are kind of the technicalities. And if you look at it in terms of expertise, we have lawyers who have that specific niche. For example, if it's international law. So they are able to interpret some of these cross-cutting technical legal issues. So that what we are saying as advocates is, look, we are not the only professionals that transact with the government. Then why shouldn't engineers, for example, in the Ministry of Road, construct all our roads? If that is the simplistic way we are looking at it. So those are some of the things that we...
It's not simplistic.
Yeah.
Yes.
I think
You're advancing interesting and very dangerous arguments.
Yes.
I'm not attacking any other...
One of it suggesting that lawyers are humans.
Yes.
We don't know lawyers to be humans. But anyway, we'll continue with this discussion. Or the question, just pass the microphone on your right to Halima, then go to yes, then we'll come back to you. Halima, the place where we are, and just to, as we make and pass the point from where he's left it, is the public feels pressured by not only the economic times, but also corruption. And it's been famously quoted that there's no corruption that happens without
a lawyer.
Should I finish?
Well, thank you for that question. Lawyers do not exist in isolation. We form part of the society. And some of these are as a result of, if you hear the discussions going on, that we have crisis in some of our national values. So corruption is a crisis in this country, and we're not exemption. So I will acknowledge that the society equally suffers the pandemic of corruption. And corruption is dangerous in the corridors of justice, because once corruption enters into justice system, then it means entirely everyone is compromised in terms of access to justice. So what we are saying is, during these campaigns, and everyone here is who is seeking election or to an office, it's a priority for us to actually look inward and see what we can do.
Halima.
Yes, please.
When allegations of misconduct arise in LSK, what independent structures or processes exist to investigate, protect whistleblowers, and ensure timely and credible outcomes?
Well, thank you for that question. LSK has elaborate mechanism for handling.
Such as?
For example, there's a committee that is dedicated to misconduct. So if members of this society have conducted themselves in a manner that is against the values and regulations, there's a committee that sits, investigates, and gives them equally a fair hearing and concludes by, there are many members who have been suspended, some of them are no longer practicing. I mean, yes, there are mechanisms for ensuring that members of the public are protected from advocates who are not fit.
What draws the line of transparency and credibility for LSK to be able to assert such cases? And can you cite examples?
What draws transparency? Well, we have an institution, an LSK institution, and we have structures, as I have just mentioned, which is independent and properly constituted committee that will properly look into issues that are raised. That will be my response to
I'd like to throw this maybe just to the whole room.
Yes.
Two of your former presidents, Senior Counsel Ahmed Nasir Abdullahi and Nelson Harvey, are at the forefront of talking about jurisprudence, that there's serious corruption in the corridors of justice within judges and magistrates, right? But like you're saying, to approach a judge with a proposal that would corrupt them, you're most likely going to use a lawyer, the advocate that you have. Do you think, because we have seen before that there's a radical surgery in the judiciary, and there are calls now for another radical surgery in the judiciary, should there be a radical purge within the law profession to get rid of the very many bad lawyers that are in practicing?
Who are not here presently today. I would like to go home. Safely. Yes, Latif, you're forgetting, right? Yes. All right, yes.
Thank you, Eric. Before I come to that, allow me to answer something that I was mentioned by Abna, sorry. Yes, indeed. Yeah, it's the campaigns. You can imagine. That is the same question every day. Yeah. Well, I currently sit in the Carrion Council as a general member, and indeed on matters welfare, we've been able to roll out several medical cover schemes. The latest one that we rolled out was last year, July. And also when I served at the branch as a council member, we were also able to roll out another medical cover. But that notwithstanding, at the chapter level and at the branch level, as per the Law Society Act, it is where the purview of welfare is bestowed. Nakuru chapter rolled out a very beautiful welfare summit where advocates are standing on business for themselves without even the leadership. Something that I went and benchmarked and even went and spread the gospel to other two chapters. So when we talk about welfare, just like you, just like me, advocates, you also have issues that needs to be addressed, and we need a safe space for us to be able to address them. Secondly, on the issue of the ARO, as it was mentioned, it was amended, the last amendment was done in 2014. I sit as a council representative in the current committee. We have finalized the report. We have even finalized a draft where myself as a legislative drafter, I was able to come up with the latest ARO 2026 amendment draft, which is before the committee to be transmitted to council this Friday. So these are the aspects that we want to talk about when you talk about advocates' welfare. You have mentioned that advocates are always in the conduit of corruption. Pray tell, how can an advocate be in a conduit of corruption, yet when they are being given briefs, these briefs are given as per the ARO, and the ARO does not stipulate the highest amount that an advocate should charge. It gives the least amount. So once I give you as my client the fee note, and in the fee note agreement you sign and agree, it is you, the contracting client, who is actually enabling corruption. Not just advocates. So this menace of always saying that advocates are corrupt.
Listen, I am a very corrupt person.
Yes.
Okay? I have a case in court. Okay? I'd like to bribe a judge. And I'm having a conversation with my advocate to help me bribe the judge. I am corrupt does that mean that because you are my advocate, you also are going to be corrupt because, I mean, I'm the one who's sending you to the judge?
No, James.
That's the question I'm asking.
You're mixing issues. I was addressing the issue of corruption.
I'm asking, in the instances where we are seeing advocates participating, and you've said conduit for corruption, yes, is there a need for a radical purge to break this conduit?
Yes, there is.
Okay, how do we do that?
And that is why we have the procedure. As Halima was mentioning, we have the Advocates Disciplinary Tribunal, where most of the council members who are above 15 years sit in together with the other elected members of the Advocates Disciplinary Tribunal. When you have evidence of a corrupt advocate, those are the procedures, or that is the venue through the law society that should actually go and file your matter to be heard and be dispensed with. On the issue of that judicial officer, we have the Judiciary Service Commission, which sits in and actually listens to those proceedings of a corrupt judge. But here comes the challenge. Rarely do people come and bring forth evidence. It will just be hearsay. And as you know, the law is very clear. You have to back up your facts and hearsay with evidence kwa karatasi.
The law is very clear. I was waiting for that.
Listen, the law is clear. The law is clear, but I'm just going to push back on this. Listen, and this is to, like I said, it's to all of you, right? It's not just to Wanjeri. When we had the first radical surgery of the judiciary in the year 2001, 2002, it was under special circumstances. A committee was established by the then Chief Justice, go and investigate.
Yes.
And they came up with a report and judges went home.
Yes.
All right?
Yes.
The second one was in the implementation of this constitution, right?
Yes.
The Shara Drao Committee, and they were given the job, go and talk to all judicial officers, and where you find a spec, deal with that spec. Now I'm asking, is this an opportunity for another of such? Because we have complaints from senior lawyers who have led the Law Society of Kenya, and that's why I'm having an issue with this. It's senior lawyers who have led the Law Society of Kenya being at the forefront of saying there's rampant corruption in the judiciary that affects our confidence in the judicial service system. Okay?
Yes.
So what do we do about that? You want to be leaders of the Law Society of Kenya, what should we do? And I am putting it to you that lawyers are corrupt.
Okay, before you answer that, the law is very clear that we should go for a break. We'll come back to that question when we come back. You're watching The Last Word here on NTV tonight. God do it fair. All right, welcome back. You're watching The Last Words here on NTV tonight. And we have been talking to lawyers about the upcoming elections. And we are stuck on one simple, quite easy issue that we'll dispense off in the next few seconds. The question of corruption. Quite an easy question. We're stuck with you answering that question. Then I will open the floor to everyone because we have to have resolution on how we deal with corruption. It's a societal problem. All right?
Yes.
And we agree as professionals that we have a role and responsibility to help the society at large to resolve this question of corruption.
Yeah. Yes, and that's why I mentioned, if it's your advocate who has actually done something that is illegal, we have the mechanism of the Advocates Disciplinary Tribunal and even the other tribunal that sits at the AG's office. Secondly, if it's about a judicial officer or a high court judge, there's now the provision where we have the Judicial Service Commission that sits in and listens to such complaints. Unfortunately, as we stand right now, we do not have the regulations that will actually implement on how they're supposed to be removed. Something that needs to be a discussion and how it needs to be implemented. Thank you.
Deborah?
Thank you. James, I can see you're so passionate about juris pesa. So let me break it down a little bit.
Oh, sorry, he's Eric.
Eric.
Yeah.
Yes.
If someone is looking for someone to deal with, Eric. All right.
So let me break it down. I think it's foolhardy to depend on the goodness of individuals. You must make systems work because we know that corruption is inherent in our society. And that means that we as a legal profession are not immune to that. So how do you deal with this? You make systems work. Let's go to the juris pesa issue. There's a Judicial Service Commission, as one of my colleagues mentioned, but the regulations do not stipulate how to deal with that.
That by design?
Possibly by design or by omission. Yeah, sometimes these things happen and the law is slow, it follows.
It's not clear.
No. Yeah, it becomes clear, but you see, when the law comes to follow an action, then, you have these things that occur that we did not envision, right? Now, going back to the specific issue, why is JSC not able to deal with these things? So there is the regulations, but secondly, there's also a thin line between what is decisional independence versus incompetence. There's this thing, this animal that has now come up called decisional independence, where you have a judge coming up with a judgment in total contradiction of existing precedents. I'm sure you all know what precedents is. Mm-hmm. And you go against the rules of precedents totally and completely, even judgments from the Supreme Court, and just come up with your own brilliant, we don't innovate in the legal profession. We follow norms, and that's where precedence comes in, previous judgments. So when that is happening, then you find that the JSC does actually hear cases. It's not that they don't hear cases. They hear cases, and eventually you find the judges are left scot-free on the basis of this thing called decisional independence. Okay, so that thing needs to be addressed. It needs to be addressed deeply, and that can only be addressed through conversations, stakeholder conversations between the LSK and the judiciary. We have to just tell them, let's just sit down and have a conversation.
Deborah,
yes.
Let's not deal with magistrates and judges. Mm-hmm. Let's deal with lawyers.
Okay. So
members of the bar, leave the bench alone for a bit.
No, I'm getting there.
Oh.
So
you're heading there.
Secondly,
okay.
Yes. So that's number one. It's important for this context. Number two, why do people go for options of corrupt processes? One, you want something speedily. That's the Kenyan way. Mm-hmm. I'm caught committing something, even a traffic offense. I think of how long I'm going to take in court. No, I want to. And you know that you're wrong. You want to take a shortcut. The judiciary is slow, for instance, in producing orders. So the client wants his orders very quickly. And what does he do? He says, no, can you get this thing quickly? Why do we have that kind of incompetence in the system? But there are many things. There's incompetence of judges, but there's also systems that are not working. I'll give you an example. The small claims court, you find a judicial officer dealing with 150 cases. It's overwhelming. Why not employ, there are many young lawyers who do not have employment. Employ them.
Counsel, please get to my question.
Yes, so now, if the system doesn't work...
I want to deal with corrupt lawyers.
If the system doesn't work, then you open up room. I'll give Majanja, the late Justice Majanja, used to issue his rulings.
Are you saying lawyers are corrupt because of bad systems?
I'm saying that is the only way you can resolve it.
Okay.
So that the system does not allow for corruption.
Right.
Majanja used to issue his rulings instantly, so that you're not having to pay for it. What are you going to be paying for? The ruling, he hears it and he issues it instantly. There's nothing for you to pay for.
Fine. Let's hand the microphone at the back. Jerry, please give your comments. Yes.
I think Eric, you're asking the wrong question and making a very...
Of course, I'm asking the wrong question.
Yes.
I'm asking it to the lawyers. It will only obviously be wrong.
It will obviously be wrong.
And making very grave assumptions.
All right.
Now, you cannot say that all lawyers are corrupt.
I did not say all lawyers are corrupt, Counsel.
You said?
I said lawyers are corrupt.
You see? Okay, this is semantics. But see, what I'm saying is this. When you take an oath of serving the public, like magistrates do, judges do, people, let's say, in the lands office do, that is an office to serve the public without any influence, whether it is financial or maybe personal, whatever kind of influence. Now, I think the correct question we should be asking is, what systems are there to punish errant public officers? Because let me finish.
That will be a question.
I'm getting to your question.
My question is correct.
Listen.
It is my question.
Eric.
I insist.
Oh, he's called
Elizabeth. Eric. My question is correct. And I'm putting it this way. We have seen, and there's evidence previously, of judges being removed from office because of corruption.
They have.
All right?
Yes.
Now, in most of these cases, the people who have facilitated this corruption with the judges are lawyers.
I don't, that's why we're
How do you know this? Is there an investigation that has exonerated the lawyers from this?
And is
there? The Advocates Disciplinary Committee has dealt with matters of corruption within the legal profession. True.
No, Eric.
Some lawyers have been found to be culpable on corruption. True. There is corruption in the lawyers. Now, what I am putting to you here is, in the incidences where we see many magistrates and judges being corrupt, the conveyor belt is going to be an advocate. Prove me wrong.
That's why we are diverging now. The views between me and you are divergent. You see, the thing is, let me put myself in the place of just a litigant, an ordinary litigant.
Yes.
A litigant can choose any advocate they want.
Yes.
But they cannot go and build their own court, build their own lands office, and come and set it up there and serve themselves. And so the onus is on the public officer to actually uphold their oath of office. Given that in any profession or in any given setting, there will be some rotten apples. But to say that it is rampant in the legal profession, I think that is not correct.
It's very unfair, right?
And to say, and also look at it this way. Police officers are all corrupt, but does it mean that majority, does it mean that you can get an honest one? You can get.
Police officers are corrupt.
Exactly. Yes.
Lawyers are corrupt. You don't agree.
No,
it's
no.
Okay. Let's hear somebody.
All right. Where's the microphone on this side? Yes, please. Yes, please stand and pass the microphone. Yes, at the back. Yes, please. Please stand. Introduce yourself. And what's your contribution?
Well, good evening.
Good evening.
My name is Wasonga. Pleasure to be here. Pleasure to be here. Now, concerning corruption, I think we are not speaking to the truth of the matter. The truth of the matter is that we live in a country with a new constitution without constitutional behavior. So when we start saying that who is young, who is old, well, the country is young. This country is as young as August 2010. Therefore, any form of constitutionality is 15 years old. Now, concerning corruption, corruption exists in a space where there's a lack of morality. What is corruption? A lack of morality. When someone sits on a bench and says that you are making too much money and you should not get this money. It's the same thing they talk about footballers, NFL players and all this. You're making too much money. Well, for a minute, let's stop looking at that side. Let us look at the base of the Maslow's hierarchy of needs, because we all have a base, you know? There's 20,000 of us. Now, at the base of this conversation on welfare, especially around remuneration, there's this interesting innovation, beautiful if you ask me. It's called the Small Claims Court. Now, the Small Claims Court handles matters that are a million and below. Forgive my French, a million and below. Now, 60 days, they're doing 54 days, turnaround times, 90 days and all that. However, so many of us are practicing there. I started getting there recently. But the thing is, you find JOs, they are called JOs, judicial officers. Judicial officers are issuing costs which are putting us below Watosmoki. And no disrespect to Watosmoki, they're doing a good job. You find, for instance, a matter you have carried for 54 days. And this is something I've gone through. You've carried a matter for 54 days. Your client is happy, they've gotten their orders, yay, kumbaya, you know. And then someone, somewhere, says that I am giving costs to the advocate 1,500 shillings. You've been there for 54 good days. God has made the sun go up and down 54 times. And then someone gives you that. Now, it reminds me of the Stanford prison experiment. And it's one reason why I'm here today, to say this. Please, and I know people are watching, just look at the Stanford prison experiment, and if one is a JO somewhere, because we don't need to go to court about this. If it's Tamil, and this is something, we have 3 people who want to do something about our welfare, because that is what VPs do. I believe that this is something that the victor should look into, because Section 20A of the Small Claims Court Act says that the CJ and the LSK, that is one of them, will sit down and talk about the remuneration. Now you have people talking about the remuneration of the base of the pyramid, and they're issuing orders which do not make sense. A demand letter per the ARO is 1,300 Kenya shillings. You have prosecuted a matter to the hilt, and it is concerning a matter, minor subject matter 750,000. And then you get 1,500. You just laugh. So I believe that anyone who is going to step up for VP, this is something you need to talk about.
Okay. How should this be handled? How should this be addressed?
Emotional intelligence, for one. Emotional intelligence. That's what I believe this country needs. We are over litigating, over constitutionalizing. Good governance, Article 10.
All right.
Be human.
Okay. Thank you. All right. The microphone was on this side. Yes, please. Yes, it's you.
Hi, my name is Gilbert Mitola. I'm an advocate. You know, Eric, your question is very specific and directed, which is how should lawyers deal with corrupt lawyers? That's the question you're asking, right?
Finally.
Not about judicial officers, not about what's happening in court or whatever, just how should lawyers deal with corrupt lawyers?
Yes.
And the question I'll throw back to you is, how does a mother eat her children? In all reality, I don't think that a member organization, that is the Law Society of Kenya, would then go into the job of investigating its own members, finding those who are corrupt within itself, flashing them out and sending them away. Although you would want to act like you have such good values and pontificate, you are not being logical or practical. Again, goes back to Deborah's point on institutions, right? This is why we have, for example, the Advocates Disciplinary Tribunal that deals with professional misconduct, which is defined. All of you did professional ethics and you know what is in SOPEC, isn't it? And what the SOPEC says. If you go against what SOPEC says, there are consequences, whether at the Advocates Complaints Commission or at the Advocates Disciplinary Tribunal. When we get into the issue specifically of corruption, we have the Ethics and Anti-Corruption Commission that has a constitutional and statutory mandate to handle these sorts of things. We have officers, DCI and everyone who have hunted people left, right and center and brought them to book. So the question should be, of all those who have been brought to book or not brought to book, as the case may be, how many of those have been advocates? How many of those have addressed this specific issue of advocates in court who are corrupt, or advocates at the lands office or wherever they may be practicing who are involved? It's not an issue that's unique to advocates. And again, another point that has been made, all Kenyans are struggling with this issue of corruption. So, for me, my view as a member who is not vying for any position is that it would not be logical to ask the LSK or any candidate or anyone else, how do you purge your own members? These guys are looking for votes. They'll not answer that question, honestly.
All right.
But even more importantly, even if we gave you a response, that response would not be practical in terms of how the society itself can purge itself of its own members.
All right.
That's my response.
Let the microphone flow, please. The microphone at the front. Just pass it, yes. The microphone at the front. Where's the microphone on this side? Yes, pass it the front. Yes. Please, yes.
Yes.
Please stand.
So I think my colleague Gilbert has answered the issue of corruption within the society well. I would want to push this back to certain issues that were raised at the start. One of them is this purge in the judiciary, having this radical surgery. Most of those people who are complaining now were part of those judicial radical surgery that happened a few years back, right? So they are still complaining, and they were part of the recruitment of the new crop of judicial officers that are there. So do we blame them first that they recruited to us corrupt judicial officers? So it is also a self-reflection to the society that as we complain on radical surgeries and all these things, it's a societal issue. Kenya is facing a big issue with corruption. Corruption is killing our healthcare. Lawyers are complaining about healthcare. It's our society, it's our economy. So we are paying for the consequences of non-good governance, not respect for rule of law, And lawyers will continue complaining about the same thing. Our economy is not doing well, right? So lawyers are complaining, my colleague here, small claims courts are giving them low returns for their job well done, right? So we are paying for the same economy that is failing everyone else. All professionals are paying for lack of jobs. Private companies are closing. Our companies register every day puts about 200 companies that are closing down. What does that mean? It does not only affect the drivers, the people who are working within that sector, it also affects lawyers who have been working within that sector. So I think paramount enough for us is to ensure that Section 4 of our Act, rule of law, lawyers do not tire to do it. Because once we stop giving up on our systems, on the rule of law, then this country goes to the dogs. And lawyers will suffer it. Will suffer it completely. Thank you.
Right. On this side, yes, please stand, and then turn the microphone on the front. Yes.
Thank you very much, James. My name is Wycliffe Foyo. I am an advocate and a council member at the Nairobi branch of the Law Society of Kenya. I'm aspiring to represent members at the National Council. So according to him, probably my answer to this question will not be objective, but I think I want to be very objective. Eric, I think when you talk of corrupt lawyers, that's a misnomer. There is nothing like corrupt lawyers. For the simple reason that the lawyer is not the beneficiary of the corruption. Unless, of course, you mean our members at the bench, but at the bar, lawyers do work and earn fees from their work. The corruption we are referring to here is facilitation probably for members sitting at the bench. From our side, you have been told, and I fully concur, that we have robust mechanisms to deal with malpractice and lack of professional integrity. We have the Advocates Complaints Commission, we have the DT to try cases where lawyers, for example, swindle clients of their money, where lawyers do not behave in a manner that upholds professional ethics. But when you talk of the lawyer probably facilitating the issuance of a bribe to a judge, and then you call the lawyer corrupt. The lawyer is not receiving the money. The lawyer is not receiving the money.
You said you want to be objective,
we must, as a matter of course, place it where it is.
Yeah.
The person not receiving the money cannot be the corrupt person. I think we must define corruption in these very clear terms. But let me finish by saying this.
Yes.
That again, to answer Eric, it is possible that the client may want to corrupt a judicial officer by not passing through his lawyer. And these are things that happen.
Yes.
Sometimes the lawyer is even surprised that the judicial officer was compromised. Yes. But let me finalize by making this point that no matter the legislative interventions we have, I defer to the wise words of my teacher, Mwalimu Elisha Ngoya, Senior Counsel, that you cannot legislate good manners. We are an ill-mannered country.
All right.
And before we deal with that, these questions will keep coming. Thank you.
Pass the microphone to the front, please. Yes.
Thank you so much. My name is Nerima Were, and Eric, I'd like to answer your question by taking a contrary position. Yes, a mother cannot eat her children, but we started this by saying the revolutionary role that lawyers have played in very many different settings, including with multi-party democracy, including with the 2024 Gen Z protests. And the question really is, yes, we can't legislate good manners, but we can lead in acting out what Chapter 6 says of leadership, because it is our constitution, and it will not come alive until we make it come alive. And this is to say, while we cannot purge it by ourselves, we have to stand and say, where does the mandate come from to purge? And that comes with, why do we do this every 2 years? Because we understand that every 2 years we must assess and see, did who we voted for 2 years ago really do what they said they were going to do? When we say Okoa LSK, Brave New Bar, it's not for nothing. All these movements arose from seeing an inefficacy in a society, and that inefficacy starts from also understanding you have different duties to your client, one, to your colleagues, but then also to the administration of justice, not to the court, the administration of justice. And if you're a hindrance to the administration of justice, then you're bringing down the bar, which then means, what is our role? If every lawyer who started in a position didn't actually consider what their role is in moving the country forward, what is the road to Singapore for us if we're not going to take? What is the road to Singapore if we're not going to take those steps ourselves and really sit down and say, in our self-assessment, how do we move forward? Nelson Mandela, lawyer. Barack Obama, lawyer. We can transform society if we actually put our mind to it. Our privilege cannot be for nothing. And to answer your question, maybe we don't have the mandate to purge yet, but I would believe if we wanted to purge, the mandate must come from the members. It can't come from the state to ask us to purge. It can't come from ethics and anti-corruption, but it must come from the members to say, listen, where we have reached, we cannot continue as a bar. We have to start removing people.
Okay.
If I had a vote,
yes.
you'd get the vote.
Yes?
Yes.
If I had a vote, you'd get the vote.
Oh yeah, I'm not vying, but when I am, please call me.
Okay, pass the back for the right. Yes. All right. Okay. Where's the microphone on this side? Yes.
Yeah. Thank you. So in summary, we...
Finally, give us the last word.
So in summary, the issue of corruption. Is there corruption? Yes, we have accepted that this is a national pandemic. It's an issue. What my colleagues are telling you is that they equally long for the day when they wake up and go to their offices and do their work with just effort, hard work and integrity, and that is rewarded. Just like any other Kenyan who is going to Kenyan institutions and they are subjected to extra costs, there are moments, even lawyers are also facing the same challenges, and as court users, they carry that burden. The other question is, what's the way forward? What should we do about it? Because remember, corruption is a threat to the rule of law. If it is left to just the way it is, then we have no country, there is no rule of law, and we are gone as Kenyans, we are gone as a society. What's the way forward? The way forward is, let's not put it under the carpet. Let's not ignore it. And LSK will take its position to also advocate and highlight, because without fair and systems that are free from corruptions, even us, our practice space, our profession is under threat. So yes, we accept that there are issues, just like any other profession is, because you have seen the other day, the Ministry of Health, it's rated one of the most corrupt. You have seen what's happening with SHA. And, there's no exception in the legal fraternity. What we are saying is, we accept that we are also facing certain challenges. It is not inherently a vice that is just identified with the legal profession. It is a national issue, and it is something that should be handled. So thank you.
I think I have one last corner to purge the lawyers. And in this teenage country of ours, it will be very interesting for me to learn. And I know we have human rights lawyers in the room. We have the crisis of femicide, the crisis of gender-based violence, the crisis of violation of human rights. And I'd want to understand, especially as we are proceeding towards the elections, what is the independence and the structural amendment for LSK to protect the lives of women, to protect the lives of Kenyans, and to separate its amendments in understanding what exactly does Kenya fortify in credible elections, and where does LSK stand in this process?
Can I add to that question? That then I would ask it's election and we've avoided to talk about the presidents for good reason. Please tell us who you're not voting for and why, as you part of that question. Who you're not voting for, not who you're voting for the president of LSK.
Yes.
Who you're not voting for?
Yes.
Secret ballot.
Thank you.
Please go ahead.
Yes,
You're about to answer the question.
Yes, thank you, James. Again, my name is Abna Mango, General Member Representative candidate. So I surely know I'll vote for myself. But the person who I'll not vote for is a person, and this is a general concern that feedback I'm receiving from members of the public and members of the bar. The LSK, as rightly mentioned under Section 4, we are tasked with defending the rule of law. So who we are not voting for is a president that will sit on the fence. We need a president that is a human rights defender. So even as they go around and ask for the vote, we are also encouraging members, because we are basically the last line of defense. And I really liked your question, because now as a matter of policy, Kenyans would want to know, are they really safe now that we are geared towards an election period?
And our neighbors have shut down the internet.
And I was going to that point. Now, and it's worrying, because if you look at the years, we are 2025, 2026, 2025 Tanzania, 2026 Uganda,
Finals.
now 2027, finals is now Kenya. Yes. So we have seen a very worrying trend. And the worrying trend is, it's, for example, it looks like it has become a jumia of abductions.
Authoritarianism.
You see, for example, yeah? And the other day we were pushing for the release of, say, Bob Njagi and Nicholas Oyo, who were abducted in Uganda. Yeah? Some of our human rights activists, the likes of Boniface Mwangi, when they went to Tanzania, the bad things were done to them. And now it generally goes back to your question on human rights defense. And you've also mentioned an issue, say, on femicide. And we thank God, for example, the president we've had, and who's now finishing her term, had a lot of passion for human rights defense, and especially women. So we need to maintain that pace and actually even increase it, so that we ensure that at the end of the day, we are a country, or we have leaders in our country who have a respect for the rule of law. And the only people who are able to do it is the Law Society of Kenya, or part of the important stakeholders is the Law Society of Kenya. So we need a president who is a defender of the rule of law, and somebody who cannot be compromised or be a fence sitter.
Say it with your chest.
Yes, members will tell. They are going down. I know them.
Yes. Deborah, and then Sophia, you want to check a part of it? All right. Okay.
Just picking up from where Abna has stopped, I will say that, we have had a run where we have seen the council advocate, really advocate for human rights defense. And that needs to continue. Yeah, but some of the things that we need to look at, for instance, and remember, we have a role not just to champion for safeguarding of the Constitution and all. We must be part of the conversation in legislation and legislative drafting. There's been this conversation about what is femicide.
What is so hard about making femicide a whole law in itself?
Okay, so now that's the conversation we need to have. And that's why we come in as LSK. We must be able to sit at the table. We are the ones who understand the law. And we must sit at the table. When you're coming up with it. Yes, we have sat, but my dear, we have to engage stakeholders. There's so many stakeholders in this conversation. Why do we have a section of the society who feel like femicide should fall within the criminal, legislation existing? It's a conversation. Yeah. But then there are those who are on the other side who feel like femicide should be a very specific crime. Where is the disconnect? Because there's no dispute about the fact that it is wrong. The disconnect is the manner in which it is described and the punishments thereof. So we must sit at the table and have this conversation. Nobody is saying that, femicide is a good thing. We're all in agreement. But we just can't sit at a table and agree, you know what, this thing is so grave that we need to define it in a specific manner. And that's where we come in as the Law Society of Kenya, where we have this conversation and just take the bull by the horns and say, this thing, it's rampant, because every day we have that conversation all over social media. The next day there's another case. That's what happens. So we are talking and talking and talking, but I don't think we're taking matters,
Deborah, are you
seriously.
seeing in the three candidates who are, gunning for the presidency, do you see anyone who has the capacity, the depth, or the willingness to take on this question in an election year?
Wow. That's a trick question.
Secret ballot.
Kura yangu ni siri. But having said that, no, let me just finalize. I think the membership knows the three candidates, and they know them in depth. And within this period, we are going to have debates where you will listen and you'll be able to judge. Aside from the debates, you'll be able to judge on what somebody has done. You know, I can come and tell you and promise you many things, but there's a track record.
Okay.
And with your track record, we can know whether you're the person. It's that simple.
All right, just hand the mic at the back, please.
I just wanted to follow up a little bit as the mic is moving, just to what Deborah has said. Deborah, you've talked about your own experience in legislative drafting. Beyond the LSK being very active on the streets, being very active in the courts, you know, with all applications and all, is the LSK really active in championing legislation, like originating legislation, and then taking it and campaigning for that legislation to go through the process until it becomes law? And is it something that LSK can actually increase its presence on? Yes.
Indeed, LSK has been, you know, part of that process, and even, you know, introduced legislation. In my view, I think there's room for improvement, to be fair. It has been part of the conversation, but there's room for improvement. And let me put it this way. I think we need to get to a point where we anticipate some of these things, you know, which requires you to assess situations and work proactively rather than reactive.
Rather than joining a bus that's already moving.
Yes, the bus is already moving. So if it's going that direction, basically, you will dandia wherever it is.
So that's why my question was on originating legislation and not coming in to participate in public participation. So the LSK is presenting its memorandum, but actually the LSK is saying we need a law, say, on femicide.
Yeah.
And the LSK is starting a conversation, meeting the stakeholders, and then saying, here is a draft bill.
Initiate, because even the drafters of those legislation are our members. They're lawyers.
Okay. Right? Yes, please.
I'm hoping that I do not have to stand, but please tell me if I do.
I think you do.
I do?
Yes,
okay.
Please.
Hi, everyone. My name is Tabitha. Obviously, I'm a lawyer. I feel that it's important, Latif, before we go to your question, to answer Zaha's question and James' question. So I'm going to work backwards. I'm going to start with James's question, which is, who am I not voting for? Luckily for me, because I'm not vying, I'm not going to be as diplomatic as Deborah. So I will tell you on national TV that I do not have faith in Charles Kanjama. And therefore, I am not voting for Charles Kanjama. And 3 reasons. One, historically, for those who may be younger than I am, I do have the eidetic memory to remember that Charles Kanjama opposed the current constitution that we have. He was part of the Kenya Christian Professionals Forum that submitted several documents before we went into a referendum in 2009. And therefore, I do not have faith in a president who has already, through his actions in the past, shown me that he does not trust this constitution. In 2023, Charles Kanjama also introduced something known as the Linda Jamii Amendment Bill, which was a constitutional bill to be able to challenge several clauses in the constitution and amend them. And therefore, that's the first reason why I do not have faith in a president who will not safeguard the constitution. Number 2 is his religious affiliation. Article 8 of our constitution talks about the fact that there shall be no religious state. But what we've seen is Charles Kanjama, as an Opus Dei lawyer and the director of the Kenya Christian Professionals Forum, has constantly brought religion into everything that he's been doing and into, you know, very serious and contentious issues. We have a bar that has queer lawyers, openly queer lawyers, and therefore I do not have faith in him to protect those who would need the protection, to be able to safeguard the clauses on Article 27 of the Constitution that talks about non-discrimination. And lastly, for me, it's because I want to show that I believe in the youth that we keep saying that we mentor. And therefore, my vote will go to someone who is much younger in the practice. And therefore, I want to test. This is the testing grounds that we have For those of us who've constantly said, I have mentored 10 lawyers, I've mentored 15 lawyers, when do we give them a chance to be able to show us that whatever mentoring we've been doing and nurturing we've been doing actually works or not, so that we can course correct? So that's to answer James. Let me go back to a very important question that Zaha asked around, what is the role of lawyers in the forthcoming elections, particularly in elections, women, and violence? Those of you who may have read the Philip Waki report, it's the most gory report that describes in detail women in Kibra who were raped and forced to have those children, and police officers who would say, keep this pregnancy because we will use that DNA as evidence in court. The role that has been played in 2007, 2008, lawyers in the Law Society of Kenya enjoined into a case that was brought by Crew and others that challenged the role of the state in protecting women against election violence. That was not a preemptive move. And I think that there's a role for us here, particularly those who advance women's rights as lawyers, to come together and be able to, in 2026, number one, have conversations with every political office person running, an aspirant, to say, you are going to sign on to a manifesto that says you have a job to make sure that you protect every woman in the constituency that you are going to be in. So there's room for us to, I can feel the politician spirit in me coming out. I might just buy.
Are you buying?
I might just buy. Call me senator. Nipeni kura. But it's important because I think that there's, and then to summarize this, I do not want for us to land again, Zaha, in a Philip Waki report, where we're looking at women who were raped, children born out of rape, where we have to deal with compensation because eventually the case did go to court and the court awarded damages. At the regional level, the African Commission has actually made a decision in the Zimbabwe Human Rights Forum case and said, private and state actors have an obligation. So it's not just the government, but when private actors in their actions or omissions do something and the government still allows for you to do it, the government has an obligation towards making sure that even private actors can be able to be held accountable. And where the government does not do that, then the government then takes the
Tabitha,
fault.
as you close up, please tell me, LSK given the chance and a green light to solve the aspect of femicide by law? Because within the movement, we are crying on the fact that we cannot get these perpetrators behind bars. Most of them walk out. Remember Kware, remember all these cases where most of us who respond are on the edge. What is that gap that can assist LSK to ensure femicide is recognized?
So Deborah pointed out to this that we have two schools of thought. We have those who say that use the existing Sexual Offences Act and any other law that was already there, right? Okay? There are those who have that school of thought, and then there are those who believe that we need to advocate for femicide as an individual standalone crime that is then prosecuted. I am not vying, and therefore, again, I would perhaps give this chance to those who are vying, but it's important to note that I am of the school of thought that we need to have a legislation that specifically addresses femicide. I'm going to receive a lot of stones for this, but I stand by it. I think that where we are at, the statistics that we have are a good indicator that we've not been taken very seriously when it comes to these issues of sexual violence, and particularly for women. There is, however, a report, and I'm sure that this report was generated and gazetted by the Office of the President recently, which is the femicide report. And therefore, what I'm going to do to shorten this answer is to say, let's have tea. Thank you.
All right, pass the microphone to the right. The right, yes.
Oh.
Yes.
Thank you very much, Tabitha. I think she deserves a bigger clap.
Yeah.
She absolutely deserves a bigger clap. I'm just going to add to Tabitha's sentiments, which I agree with completely, insofar as the need to ensure that the specific legislation, there has to be some sort of deterrence. There has to be some sort of confidence building, especially for members of our society, women and girls out there, that when they do come to report, because that's the biggest issue. One of the biggest issues is even the ability to report. There's so many barriers to reporting sexual violence that could prevent more serious forms of sexual violence, such as femicide. So advocating for a law on femicide is the least. Honestly, if this council doesn't do it, it would be such a shame. It is the least we can do as Law Society of Kenya. Internally, we have worked on developing policies such as our anti-sexual harassment policy. So we have also considered internally some of the gender-based violence issues that our members face. The time is now to ensure implementation, because one thing Kenya does very well, we are experts. Let me tell you, we have PhDs in developing laws and developing legislation and developing policies and guidelines. Enough. We need political will, we need commitment from our leaders, both internally and externally, to ensure that we stop femicide for all the way. No woman, no girl in Kenya should die because they are women. That is completely unacceptable. And as Law Society of Kenya, if I have the privilege of serving, we have to be very, very serious about election preparedness. And this is not just about sexual violence, it's about violence in general. If we have a council that ignores this issue until it blows up, we would have really betrayed not only our members but the country. So the issue of legislation is within our law, the Law Society of Kenya Act. It is our obligation, it is our duty, it's actually our ethical mandate as well to ensure that there's legislation for people to be able to access justice in our country. One other thing before I give the mic, I want us to have our own version of Release the Epstein Files, and we need to open the Sexual Offences Register. Open the Sexual Offences Register.
All right. Where's the microphone on this side? Okay. Yes, you.
There's Kavuta there.
Okay. Okay, as she gets ready, maybe I'll just mention something just to keep the conversation going. And I think this is also something that I agree, yes, the Law Society of Kenya needs to take it up. But again, if you look at the structure that we have in our constitution, the legislature is the body that is specifically mandated to legislate. And when I talk about legislate, is enact laws. So there you had asked, is it enough to just be submitting memoranda, or going to those committees and give our views in terms of public participation? So we also need good leaders who are also taking these conversations seriously now as a nation, so that, for example, for Parliament to make sure and have it a point that some of these legislations come into or are enacted into law. Now, good thing is that we are privileged as a society to have some of our members serve either in the Senate or National Assembly. So this is a conversation that we need to pick it up with some of them at their level, so that they can sponsor some of these bills and have them debated in Parliament and enacted into laws. And finally, picking from where Tabitha also left, in terms of some of these cases that we are having, I have been privileged to have been instructed by the society to act in one of these matters that are of huge public interest, and we are talking of the Baby Pendo case. This was this kid who was killed at the height of the 2013 election. But people don't know that this case was not only about Baby Pendo, but it was also about the women who suffered, sexual harassment and all kind of violence in Obunga, Nyalenda, those areas, environs of Kisumu. But it's been a fight for those people to take plea. It took around 8 years for them to take plea, these officers. And we are trying to now have a concept in law that is command responsibility, where we want even now these commanders, when issuing such instructions, should be able to face the law and justice, because some of these things were as a result. It is not just that officer who knocked that door. There were specific instructions that were issued in terms of command responsibility. So that is something that we need to also have as a nation, and not only just in that case. Now, in other cases, be it abduction case, be it the violence that is meted the other day, those young men who are seriously clobbered very late into the night. So we need to have a strong society, because one of the challenges we had in that case, as I finalize, is that those superior commanders that were to face or take plea in that case, at some point somehow we lost them. So we are now trying only 4. Initially we had 13 of them. So this is some of the challenges that we are having, but we still remain resolute and try to fight that finally, for example, those families that face the kind of violence in that case finally get justice, or they can at least say justice has been done for them. Thank you.
Okay, so I'm going to do this. Give the microphone to the gentleman at the back. He's been asking for the microphone since 1.5 hours ago. And then we start closing these out. Yes, please stand.
Yes, good evening. My name is Mr. Koira Kimani. I'm an advocate of the High Court of Kenya. I predominantly practice in the family area division. I wanted to speak more about the corruption part of it, but I think that has been covered, though that now takes me to the issue of femicide. What is actually the problem is that we have a highly corrupt investigation agency. The media will highlight the situation. Then once the police take that investigation, it goes on and on and on. I have been privileged. The LSK is really doing quite enough. We have the public interest division. I serve in the LSK Children Committee. There was a matter that I was given where a minor had been killed, and from the slum area. And what happens, you go to the police stations to try and get these details and the investigation. You can imagine, as an advocate of the High Court of Kenya, an entire police station misleads me. The contact, what was reported, and they tell you cannot see an OB. Then there's also intimidation part of it. These people, you'll imagine even a chief in those local communities has the power to intimidate. A chief, a local chief. Okay. Has the power to intimidate this complainant who comes forth and says probably there's a murder that has happened, or the people involved, you find probably there were 5, but only 2, and it's always the broke one who actually gets to someone with the dreadlock. This is the person who committed the crime. 4 of them are actually let free. So we have that, and how then DPP exercises these prosecutorial powers, it has first to come from this corrupt agency known as probably the DCI or the police unit. If you look at the way the courts have interpreted the issue about private prosecution, it creates a higher degree of operation. You must have gone to the probably DCI, they must have taken the claim, they must have refused. There's a prima facie evidence appraisal into it. So you find all this is a systematic issue that blocks. But if, for instance, citizens themselves, if faced with an issue where you feel that the police are biased, you can on your own now proceed. This is the evidence I have. Just in the way we do it in civil cases, you can proceed to prosecute, then that will really bring the much desired change that we want. That will be all. Thank you.
We can continue forever and ever. Are you vying for opposition? No. Okay, so she'll be the last one to speak. Then I'm going to give everyone who's vying 30 seconds to do an elevator speech on why.
Why you?
Why you? And then Latif will close the show for us. Yes, please.
Thank you for this chance. My name is Dori Munji, and let me say we're going to vote for someone who will be upholding the rule of law and also making sure the welfare of the members is a key concern.
Would you have a name?
My name is Doreen.
Name of that person.
Who is your candidate?
No, let me
pressure.
proceed.
No pressure if you don't feel like. But
so let me say this. So many people are avoiding this topic, but slowly the legal profession is becoming accessible to members who can. The legal profession is a privilege to members who can survive unpaid labor or low wages for their labor. So what we don't want the LSK to become a trade union. We have seen PDU fighting for the interns. So we want the LSK to have a framework. They don't have to negotiate for the salaries like PDU do. We want them to have a framework where we'll have a standardized mode of payment to their pupils. Yes, that is my point.
Thank you. Thank you, thank you. And since the microphone is there, let's start with you, your elevator speech. 30 seconds at most.
All right, thank you very much. My name is Wanjeri Elizabeth Ongwe, and I'll be vying for the position of Vice President. Now, I am best suited for this position. Over my 19 years of practice, I have had the opportunity to know the challenges that face the legal profession and solutions that are needed. I am a proactive person, and I am guided by service that results in solutions and improved member welfare. My greatest contribution so far to the society has been the reduction of CPD event prices and the issuance of certificate of good standing free of charge. But I do realize that there is more to be done in terms of welfare and practice issues. And on the basis of that, I request you that you vote for me as the Vice President of the Law Society of Kenya in the upcoming elections. Thank you.
All right.
Thank you for the opportunity. Well, members of the bar, I come before you once again. My name is Teresia Ovinya Nicholas. I am aspiring to be your next vice president. I have currently served you as a general member, and I've been able to actually draft the new amendment of the ARO, which is going to improve our bread and butter, hence increasing our monies in our pockets. Because poverty is the enemy. Allow me to finish that by ensuring that the Chief Justice will actually gazette it. Secondly, you have seen me fighting for our spaces, safeguarding it against the masqueraders and against the quacks who have been coming to infiltrate our society. We have gone ahead as a general member to ensure the task that I started together with my colleagues Gloria Kimani and Stephen Bugwa at the Nairobi branch has been now cascaded to all the branches where we have brought them on the decision table so that they be able to tell us how they want us to eradicate the masqueraders at their branches. Most importantly, when I was admitted as an advocate, together with my colleagues, we realized that the young lawyers had no voice. We went ahead and formed the Young Bar Association. I became the first director welfare, hence the name you nicknamed me, Mama Welfare. Allow me, as I exit the arena of leadership, to go and fully structure welfare across all chapters and branches so that the society can have a dignified manner on how we implement welfare. Teresia Vinya Nicholas, kazi iendelee. Thank you very much.
No pressure whatsoever.
You know they say save the best for last. Why Deborah? First and foremost, experience. Experience counts for something. I'm the only candidate who has a diverse 360 experience in private practice, in corporate conveyancing, NGO, and corporate governance. You won't find that anywhere else. So that experience, that is me, number one. Number two, a proven heart for service. I have served this society from when I was a young lawyer. Most people think because I'm turning 20, I was never a young lawyer. FYI, I was a young lawyer. I served in the Young Lawyers Committee and moved to in-house lawyers committee, moved to the CPD committee, served in the welfare arm, which many people don't know about, where we handle directly the mental health issues. It's disheartening, but we have actually supported many lawyers on mental health issues. Alcoholism, I will speak about it because it's a real issue. Yeah. It is not just an issue that impacts the rest of the society. It's real. We have high pressure jobs, and the Advocates Welfare Association, Benevolent Association has done cases. We've had medical cases where our lawyers have had accidents, and we've assisted them, speedily. So those are real, tangible things which I have done. And so I understand welfare, yeah? And finally, I am accessible. I am accessible.
What's your number?
I'm accessible. Oh, you want my number? I'll give. In fact, even you don't even need to have my number. I'm on all social media platforms and
omnipresent.
Omnipresent. Kila pahali.
All right.
Thank you.
All right. Then 30 seconds, 30 seconds, 30 seconds, and 30 seconds. I need to be out in less than a minute. Yes.
Thank you. Abner Collins Mango is my name, and thank you for having us here today. I'll be seeking a General Member Representative seat. So my mantra and vision is having a member-centric society geared towards protection of the rule of law. That is what I'm contesting under. And just to answer the question that I've had on the issue, especially because it touches on young advocates, the issue of sexual harassment and payment of pupils and young advocates is something that the Law Society of Kenya needs to pick up, which I will, in terms of having one, as a matter of policy, and two, also picking it up with the Kenya School of Law that is primarily tasked with ensuring that this kind of training is done. So we shall be meeting, we shall interact when I do the door-to-door and have other platforms, but remember the name, Abner Collins Mango, the low-hanging fruit. It's mango season, so the time is right. Thank you.
All right. Yes, 30 seconds, please.
Thank you for this opportunity. My name is Halima Ali. I am vying for the position of Nairobi Rep in the upcoming elections. Why me? I have experience in private practice. I have experience in corporate world. I am familiar with the challenges that are faced by private practitioners and in-house counsel. And that gives me, again, a wider view of what exactly we are facing as members of this society. Equally, I am one of the, I emphasize on the need for us to build an institution, LSK institution, to secure our profession. The council is the most temporary. We have only 2 years in that council, but we have a secretariat, and it's high time, as candidates, we actually think of building LSK as an institution so that we have efficient services. The other thing is, I am energy and natural resource lawyer. It's a niche. I'm advocating that for those of us who are actually saying that we are admitting a lot of young advocates into the field, it's high time for us to also, while doing our traditional practice and protecting it, to consider alternative pathways. Why? It gives you a platform even at global level. Right. You know, issue of cross-jurisdiction is no longer the feature. It is here with us. So if you want to offer your services across the border, then you have to position yourself in emerging sectors. This is Halima, and thank you. Please consider me for Nairobi position. Asanteni sana.
All right. Thanks.
Thank you very much. Once again, my name is Sophia Wangeshi Rajab, and I am vying for General Member Representative of the Law Society of Kenya. My slogan is fight for my members, fight for the nation. And that's not just a slogan, it's a commitment. I am extremely passionate about fighting for my members, ensuring that our members have a livable and dignified wage. It really is the least we can do. And that is really one of my bigger priorities, ensuring that welfare issues are taken care of and bread and butter issues at the front lines. When it comes to fight for the nation, I think everyone here in this room today and the people outside of this room, in the audience, regular Kenyans, understand that the Kenya that we live in today, this is an authoritarian state. There is shrinking civil space. There is a violation of the right to freedom of expression. And if we don't take care as lawyers, particularly those who want to serve in the council, we will descend into more authoritarianism. That's the word. So the issue of constitutionalism, rule of law, integrity is really just the base minimum. If there is a council member who is not putting those as a minimum, then that's a concern. So constitutionalism, rule of law, and integrity are bare minimum. I said that I'm a fighter. You spoke about Maandamano, Latif, earlier. During the Maandamano time, during the femicide protests, I was at the front lines. I'm in a nice suit today, but trust me, when it comes to Maandamano, when it comes to protests, I have consistently, throughout my 15, 16 years of practice, fighting for human rights, fighting for the protection of human rights across the country and across the globe. So those are my commitments as a person who's vying I will be in the front lines. Gloves will be off. When there's time for dialogue, there'll be time for dialogue. But trust me, when our members are calling for us to be on the front lines and fight, I will be on the front lines fighting.
Oh, there's one final, yes. 30 seconds, please stand.
My pleasure. My name is Wycliffe Foyo. I'm vying for the position of Nairobi representative to the main council. And I think I'm best suited for this position because I know the job. I don't theorize about the job. I am doing the job at the Nairobi branch. I have done the job as a committee member of 2 important committees of the Law Society of Kenya, and I currently convene the tax liaison and the PIL committee of the branch, from which we have been in the streets in 2024 during the Gen Z protests. We have held various legal clinics around the country, and we've delivered one of the most vibrant branch councils since the Nairobi branch was constituted in 2016. I have spoken for the branch. I currently sit at the branch executive, and I lead a lawyers branch and body that has 76% of the membership of the Law Society of Kenya. Of the 18,000 people going to vote, 13,000 of them are my members. They have trusted me at the branch, and I am asking them to trust me together with other lawyers across the country to the National Council, for the reason that my scorecard, my track record, my contribution to this society is not only unmatched by the very good people vying for this position, but presents the most practical solutions we want for the society. And specifically, I am looking at having members be at the forefront of what we are going to do, because we have collected views from the membership we represent, and the members are saying the balance we've been discussing the whole evening today, can it now tilt towards looking after the member more? Because it is only when the member is well taken care of that then we can go out there and present the public, walk in courts, get out those in distress. We can't do that if our members are suffering.
All right.
But last and finally, my candidature
your
is
final.
The
last
yes. I'm a politician, James. I can have last 3 times. But last and finally, I'm also looking at having a strong council, not only of me as a Nairobi representative, but everyone across the board who will be elected. And that is the plea I have to the membership of the Law Society of Kenya this evening, that let's elect a strong council and not those who will come and disappear after the election. May God bless the Law Society of Kenya. Thank you.
Tyranny of numbers. 13,000 of the members are in Nairobi, and they've trusted me.
Yes.
Anyway, please.
Well, I think we've had a vibrant conversation tonight, and I want to thank everybody for their participation. And I think it's clear that you all have a passion for your profession and for the society. Now, we were asking the question, does the public actually feel the Law Society is not just a members' society, but also a public society? One of the mandates that, as is already out here, is also to advocate for public interest. Are you doing a good job of that? Now, there's evidence to show that you actually are, as the Law Society of Kenya, because we've seen the amount of cases, right? A number of cases, legal aid and support that's been given to the public. Of course, just looking at the last 2 years, a lot of work has been done on that front. We've just talked about the legal clinics that have been conducted by the Law Society of Kenya, just to create awareness and enhance awareness on law, enforcement, or against fake lawyers. And yes, that was mentioned by a candidate that, you've got rogue elements amongst you, and you've done a good job of weeding them out because they didn't go to school like you did. Okay. There's active advocacy for constitutional and constitutional rights. Many petitions have been taken in a public interest litigation that's gone to court. Yes, the Law Society of Kenya has done that. There's also a bit of evidence that, there's some job that could be done that's not being done. For example, if you look at the Legal Aid Act and the lack of proper implementation of that, and one of the senior lawyers in this country, Waiko Onyoike, has actually been advocating for this and saying, how can the Law Society of Kenya push better for the proper implementation of the Legal Aid Act that allows more people to have access to advocates? That's something that the Law Society could do. Rural and marginalized areas still underserved, yes. an advocate from Kilifi has just said, look, where we've been practicing, we feel underrepresented. That is something that's coming out of there. So the Law Society of Kenya could do that, not only for its members, but for the public as well. For the public across the country to feel the presence of lawyers. Mixed perception and political pushback. This is a dicey one, because the perception would be based a lot on the public political perception. Now, is this law society aligned to the government or is it not aligned to the government? I mean, that is very, very subjective. But it's a conversation that the Law Society of Kenya would like to maybe think, how do you elevate yourself so that you are not judged on the politics? What's your name? Then you must be aligned to the other side. In conclusion, the Law Society of Kenya is making measurable effort to defend the public through legal aid, through outreach, through advocacy. Scale of that impact is still limited. While its actions are significant, expanded legal aids and broader public reach are needed for the LSK to fully meet legal protection needs of all the Kenyan public. That there's still a lot that could be done. And like we said, and we just posited here, for example, originating legislation and championing for that legislation, even outside Parliament, so the public walks with you and says, my MP, vote for this particular one, and such. So there's a lot that can be done. There's a lot that you've done, and that's the last word. Thank you all very much for watching. Asante and have a lovely
Thank you for coming, guys.
This is the best episode we've had.
Absolutely.